I appreciate everyone being here, being on time. Um, you probably learned that from me. I'm going to start on time, and we're going to end on time or before. So that's always a good thing. So, first of all, I do want to thank you. I think that you've been very well engaged in the class. Very pleased with how the class as a whole is doing. You are doing a very good job of analyzing some complex case law and boiling it down to its essence. And so by and large, I'm very well pleased. Before we get into the lesson, though, I wanted to open the and just see if anybody has any questions. I know that you've now done the midterm exam, and so the format of the final exam is exactly the same as the format of the midterm exam, and it's total 100% application based. Did anybody have any questions or any comments about the midterm exam that you just really got to get off your chest? I'll give you the opportunity to talk before we do that.
I do have a question. Good evening. With regard to, okay, so I understand the premise of the assessment, are being able to apply that which we are learning about, and particularly the case law, the statutes, whether or not any precedents have been set. I just wanted to make sure. So for example, if I had taken the question on like the child abuse scenario where the teacher sees this event occurring in the grocery store on a Friday, but then reports it on a Monday. If my recollection serves me correctly, we didn't have a case that we studied with regard to that. We just looked at the laws, correct? So
yes.
All we would have been applying was the Georgia state statutes and whether or not the teacher was compliant with what she was supposed to do.
That's right.
Okay.
Exactly. And family law was, I'm sorry, go ahead.
I was going to say, there was one that kind of talked about it. It was like the May one, where it said because the child was no longer within her care, then
right.
Then you couldn't. So that's how you could kind of use the case law if you wanted to, or you could talk about the statute.
Yeah.
So
now what I was really looking for there, and if you mentioned May, that was perfectly fine, was the requirement from the Georgia Code that we are mandated reporters, et cetera. And so, yeah, there will be questions that are not necessarily stuff that we talk about, because your online week, you're learning stuff that we don't talk about on our face-to-face synchronous weeks. I chose certain things for the synchronous week that are not more difficult. That's not the right term, but things that are a little more confusing maybe. I chose those for the face-to-face week. But tonight we're going to talk about due process, and the Supreme Court can't even decide, they can't even agree as to what due process is and how due process should be applied in the school. And so that's why I chose this as a week. So now, if you did that also, Tara, to answer your question, there are wrong answers, but there are also lots of right answers. So as long as you supported what you thought would happen in that scenario with applicable Georgia Code, case law, best practices, et cetera, you're going to get full credit. And you don't necessarily, your right answer may not be the same as somebody else's right answer. And that's fine. That's fine. I hope you've learned that there's a lot of gray in the legal system. And that's kind of part of the unspoken goals is to learn to navigate through some of that gray.
Okay. Thank you.
Yes, ma'am. Anybody else have anything?
I know that we are on the graduate level working, and it's just something to consider. I'm a mathematician, so I think with the midterm, I kind of struggled with writing that fast. And I feel like it was a lot of pressure trying to write that fast.
In 2 hours?
So I feel like I'm going to have some errors. I feel like I didn't really have time to proofread and just kind of really process. I'm a mathematician. I'm not a writer.
Okay. Well, I'll keep that in mind. I mean, at graduate level, there is an expectation that we write scholarly. And so that's why there is part of the rubric is mechanics and grammar. But it's not a major part. So as long as as long as it's not so egregious that I can't tell what you're trying to say, then you're going to be all right. I mean, I hope you found out you're going to be all right. I don't think anybody's doing poorly grade-wise in this course. So that's why I said I'm really pleased with the work that you're doing, because it's, by and large, you're engaged and you're right where you need to be. I don't think the midterm's going to be any different. I did look at a couple of people's, because a couple of you did it early. Those of you that did it yesterday, I've not looked at yours yet, but I did look at a couple of people's just to see. And what I saw was right on, was spot on, exactly what I wanted to see. Okay? And I will do my best to get those graded. I know you want them as quickly as possible. So I do have Thursday off, so I'll have some time to grade Thursday, I'm sure. Any other questions before we get into content? Okie dokie. And then let's head on. Let me share my screen. All right. If you're seeing my Google Slides, give me a thumbs up. Thank you. All right, so last week you got to spend some time learning about search and seizure, and that is also going to really play into our discussion this week of due process. We're going to be looking specifically tonight at the Fifth Amendment and the 14th Amendment, because both of them speak to due process. Now, they're about 80 years apart when they were written, and so the historical context around due process, the concept of due process, is not 100% consistent. And so that could be some of the reason that the Supreme Court's never really agreed on a standard for due process. Excuse me, I'm going to turn my phone off completely. My family is having a fantastic discussion without me, and I'm tired of the buzzing. All right, so my phone is off completely. All right, so as I said, we're going to talk about due process tonight, but keep in mind your ideas about search and seizure that you talked about, because some of it will certainly come into play, because when we search and we seize, we could be violating a person's right to freedom, their freedoms of expression, of liberty, life, liberty, and property. So we could be limiting one of those by searching and seizing, and we can only do that, remember what the 14th Amendment said, when we talked about several weeks ago. This says that that the government shall do nothing to limit a person's right to life, liberty, and property without due process of the law. So that's definitely going to come into play tonight. The thing to kind of remember, to keep into your brain, are two concepts that you learned last week, and that was the concept of in loco parentis, that administrators, and in the courts have even extended that to teachers and teacher leaders, that you do act in loco parentis in the school, that you act as, or the administrator act as, the local parent of the student. And so the administrator can make decisions for the student as if that administrator or teacher is that student's parent. And so the courts have upheld that very consistently, that if long as you are making a decision based on what you think is in the best interest of the child, you're acting in loco parentis. And so the court has upheld that and not held anyone responsible for any type of negligence, as long as you're trying to act in the best interest of the child. The other concept is that I want to make sure you understand is that administrators in search and seizure are not held to the same level of accountability that law enforcement personnel are. Law enforcement personnel have to have probable cause to search and seize, whereas administrators only have to have reasonable suspicion. And so the idea of reasonable suspicion could be something as small as a kid comes up and says, I think that kid has a knife on him. Well, that's enough for an administrator then to be able to search that student. It would not be enough for a law enforcement officer to search that student. So that may be why sometimes you see in your own schools that the administrators are taking the charge in an investigation, that the SRO maybe is just standing back. That's because the SRO doesn't have necessarily probable cause. Now, when the administrator searches and finds the knife, then the officer can step in, because that would give the officer probable cause. Or if the administrator shares information with the law enforcement officer, the SRO, the school resource officer, some of that information could then give the SRO probable cause. But administrators only have to have reasonable suspicion to search and seize. And so that is just a total different layer of how the law works for administrators. So administrators have a lot more levity in searching and seizing than a law enforcement officer does. All right. So our essential questions tonight, things that you're going to learn is, what is due process? So we'll come up with an operational definition, and I know you've already got some of that from your reading. How has due process evolved from a historical perspective? And we'll talk about both the Fifth Amendment view of due process and that 14th Amendment view that were written about 80 years apart, and they were really serving two different purposes, but now both impact us as educators. What is meant by procedural due process and substantive due process, because they're two different ways to look at due process. And what type of due process has greater implications for us in the educational arena? In what ways do due process rights impact education? How are due process rights conferred in the educational setting? So in what settings, basically, or what events do we have to give due process, and how is that due process given? There's some pretty specific things that we have to do in education to make sure that we're meeting due process in education. Okay, so before we jump into the meat of tonight's lesson, I want you to think about this question, that if freedom suggests the liberation from structure, if freedom suggests the liberation from structure, that if you are free, there is no structure or rules, do we really have the freedoms of life, liberty, and property? Not asking you to answer out loud yet. Think about that rhetorically just for a second. If freedom suggests the liberation, that we're free from structure and rules, do we in America really have the freedom of life, liberty, and property? Anybody want to take a stab at that question? It's rhetorical.
It sounds like freedom from structure sounds like anarchy to me, which would eventually, in my opinion, still the pursuit of happiness and what we enjoy in our society as far as the pursuit of life, liberty, and happiness.
Okay. So then, Joseph, are you saying that we don't really 100% control our life? We don't 100% control our freedom of speech, or 100% control our freedom of expression, and we don't 100% control our freedom of property? Is that kind of what you're saying? That if we did, it would be...
Well, yeah, I'm saying there's rules and laws, definitely. We're not free from having any restrictions, and that's to protect us. The same reason why we have rules for our children. It's not to it's to protect them ultimately. Okay,
and to protect the greater good. So it's maybe not just protection of us individually, but to protect the greater good. Very good point. Anybody else want to take a stab at that question?
I would say that even though we have freedom, that the freedom comes with responsibility and accountability, because in the exercise of our freedom, it ought not to infringe on somebody else's freedom.
Mm-hmm.
Very good point. So exercise of our freedom should not infringe on someone else's freedom. Okay, very good.
I was going to say something along those lines, in that while we have freedoms, we don't have we're free to do what we want, but we're not free of consequences if those things, like Tara said, impede on others.
Okay. All right. So consequences are in place when we do infringe on the freedoms of others, or if we take some of our own freedoms to an extreme. You know, it's kind of that old adage of, you can't walk into a crowded theater and yell fire when there's no fire, because you are putting other people's lives at stake then, even though you do have the freedom of expression and freedom of speech, but not if it's going to put other people's life at stake. So you would be then impinging upon their freedom of life. Okay, good point. Any other points to think about? This is good. This idea is going to come back into our discussion a little bit later. So I was just kind of curious, taking a little barometer check or thermometer check on where the temperature of the class is. Anybody else want to jump in and give it a shot? Okay, then we'll move on. All right, so the Bill of Rights. The Bill of Rights, I'm going to give a quick history lesson. I certainly don't profess or claim to be a historian or a history teacher, but the Bill of Rights certainly come into play in our discussion of due process. And as you probably remember from civics class or from American government, that the Bill of Rights are the first 10 amendments of our Constitution. And that Bill of Rights was written in 1791. So 1791, not long after we declared our independence and started, or created our own country as its own sovereign nation. It was created in reaction to the distrust of central government in England. We've already talked about that a lot of our early on laws were in reaction. That separation of church and state idea, the Establishment Clause, was a reaction to the oppression that the settlers of America felt from the English government in Great Britain. They are the first 10 amendments of the Constitution, and they were ratified to ensure that central government would not run roughshod over an individual's civil rights. So they are to give us our own rights, and that they are to actually limit the power of the government. That is the whole purpose of the Bill of Rights, which really is, if you think about it, that's really kind of a wild thought that a government would, and all of the forefathers of our nation wrote the first 10 amendments so that they were limiting their own power because they were the ones who founded our nation. So they did that to limit their own power so that we the people, in order to perform a more perfect union, establish justice, ensure domestic tranquility, that we have the rights, that we are the ones that are governing the world. Are governing our country. This is for the people. And so that's kind of an interesting concept, that there are not many governments in the world that actually have precepts in their own constitution or in their own set of laws that limits their own power. And so these were to make sure that they didn't run roughshod over our own civil rights. First Amendment we've already talked about, that gives freedom regarding religion, speech, press, peaceable assembly, petitioning, and redress of grievances. So you are now a pretty strong expert on First Amendment. We talked about that a lot. Second Amendment does give us the right to bear arms. That's a hot topic of discussion politically today, with some differing ideas of what that means from that run along party lines. But we do have the right to bear arms as a constitutional right. Third Amendment, right to own property without governmental intrusion. And so we are allowed to own our own property in America without the government telling us where to settle and how to settle. We can do that on our own. Fourth Amendment, protection against unreasonable searches. That kind of goes into your discussion from last week. Fifth Amendment, guarantee of a grand jury indictment in capital offenses, protection against double jeopardy or self-incrimination, right to due process. We've already talked about Fifth Amendment a little bit. We'll talk about it more a little bit later. And right to own property and receive just compensation when needed by the government. So that's when the government exercises eminent domain, that if they're going to build a new road and they're going to take some of our property, they have the constitutional right to do that. But they can't just take our property without giving us just compensation. Of course, the word "just" is a term that's left up to scrutiny and left up to different ideas, and so that's why we'll see some court cases when eminent domain is used, where people are trying to get more money for their property, and then the government just steps in and abandons the property, and so it's basically worthless at that case. So. But Fifth Amendment does guarantee the right to due process, and so we'll talk about that a little bit later. Sixth Amendment, the right to a speedy trial by an impartial jury of your peers, with the right to notice of accusation and right to face witnesses. So that's really part of due process, that once you go to trial, that you have the right, that's part of your due process right, to know what you are being accused of and to have the right to face those that are speaking against you. You have the constitutional right. That's why all of the people who testify against you, you have the right to know who that is. In some cases, they're protected because of their right to life. That does happen sometimes, but there has to be due process in case we're going to limit someone's right to life. You have the right on the 7th Amendment, right to trial by jury, and protection against the excessive bail and against cruel and unusual punishment, which is the 8th Amendment. The 9th Amendment, that citizens have other rights not specifically mentioned in the first 8. We call this the catch-all amendment, because if there's any other thing that you've got rights to, this basically says anything else that would be a good cause for citizens to have rights to, it can fall under the 9th Amendment. And then the 10th Amendment, that powers not delegated to the United States by the Constitution are reserved for the states. So this is another kind of catch-all right or amendment that says that anything that's not covered in the Constitution of the United States is then delegated to the states, individual states. Education being one of those areas, not mentioned in the U.S. Constitution, as we mentioned several weeks ago, because that is the responsibility of the state, and all 50 states then do have information in their own state constitution about education. Okay. Any questions or comments about the Bill of Rights? Just wanted to give you a quick overview, because that will come into play in a further discussion of due process. All right, let's look a little bit more in depth at the 5th Amendment, because we said the 5th Amendment does mention due process, and you can see in the area on the slide that I've highlighted in red or changed to red font that no one nor be deprived of life, liberty, or property without due process of the law. Sounds very familiar. We heard that verbiage in the 14th Amendment that we looked at a couple of weeks ago, and so that no person shall be deprived of life, liberty, or property without due process of the law. Now keep in mind, it doesn't say that a person can't be deprived of life, liberty, or property. They can, and we know that they do. In education, we do deprive people of their rights, but we can only do it with due process if we've given them due process of the law. You as a teacher have due process rights. You may not know that's what's being afforded you. Like when you write up a student and you write what happened on a referral, you write what happened in your class and you write that student up and you submit that referral to your administrator. That due process right, what you are doing is showing due process. So you are getting your chance to show your own due process. So you're getting your due process by what you write on that referral. And we'll talk more about discipline a little bit later. Okay. There we go. All right, so limitations of the 5th Amendment. So the Bill of Rights were to protect an individual's freedom and their civil rights against the federal government, the central government. That's big government. That's Washington, D.C. government. But it did nothing to protect individuals against state government. And so that Bill of Rights, because it was a reaction to what happened in England and the reaction to the oppression that the early settlers felt by the English government, it only protected the citizenry against federal government. It said nothing against state government. And so a little bit later, about 80 years later, comes the 14th Amendment. And we talked about this a couple of weeks ago. The 14th Amendment has very similar verbiage. It says, nor shall any state deprive any person of life, liberty, or property without due process of the law. So the big change here is nor shall any state deprive any person of life, liberty, or property without due process of the law. So if you look at them side by side, they do look very similar. That the Fifth Amendment says no person be deprived of life, liberty, or property without due process of the law. And then the 14th Amendment says, nor shall any state deprive any person of life, liberty, or property without due process of the law. So really the essence of all legal questions comes down to, was the person's right to life, liberty, or property deprived? And so on your case analysis, I really would like you to get to where you state all of your legal questions as a deprivation or a limiting of someone's life, liberty, or property right. Okay, so most of you ask the right question, you just don't ask it in that form. So I want you to kind of think that way now, because we've talked about how important that concept is to law. is so as you do further case analysis, really do try to figure out a way to write your question, your legal question, in the form of, was this person's right to property deprived when X happened? Okay? If you do that, then the essence of how the courts decide whether or not it was deprived, they'll decide whether it was justified or not, and whether or not they received due process. If they received due process, it could be, yes, their right was deprived, but it was justified because they received due process in this case. So I hope you'll get to that point. I haven't been, marking off, but I've been just giving you comments that say, could you reword it this way? So be thinking about that. So the 14th Amendment was ratified in 1868, about 80 years later than the 5th Amendment was. It was originally intended to guarantee rights to newly freed slaves. So we're talking post-Civil War era, that the newly freed slaves were there, and they basically had no rights, but now they were finding themselves freed. And so this was to guarantee rights for those newly freed slaves. It did create that hierarchy between the federal and the state government, that the federal government is superior to state government, and so that the state government may do nothing that conflicts with the federal government. So they can't make a law that conflicts. Well, they shouldn't make a law that conflicts. We certainly know they do. There's things in the that are going on in the legislature right now, in the Georgia legislature, with our the abortion law that is challenging Roe v. Wade, and which was federal case law. And so that certainly does happen, but the 14th Amendment should establish or attempted to establish the hierarchy between the federal and state government, the superiority of the federal government. It provides state protection to all citizens from various forms of arbitrary or capricious state action. And so capricious here means things that are not well thought out, that don't have a real reason, that just happen spontaneously or erratically. It's to protect citizenry against those types of actions. And that a state cannot arbitrarily or capriciously deprive the rights of a person that they have as an American. And that it also applies to those operating as a ward of the state. If you are employed by a public school, you operate as a ward of the state. And so where it says that a state cannot arbitrarily or capriciously deprive the rights that a citizen has as an American, you as a ward of the state can't deny those rights either without there being a really good reason, and without providing due process of the law. So you as a ward of the state, me as a ward of the state, as a principal of a high school, we can't deprive students of their rights that they bring with them. I can't deprive my staff of their rights, because you're going to learn next week about employment law. And we'll learn a little bit about it tonight. We'll talk about it tonight, some too, a little bit later. So I can't deprive you of those rights. I can't just arbitrarily fire you if you have tenure, because if you have tenure, that says that you have due process. You have earned a property right of a job, of an expectation of a job, and that I can't just arbitrarily fire you without giving you due process. We'll talk more about that a little bit later. And that due process eliminates that arbitrary and capricious deprivation of rights. I think I explained that. So this is the essence of all legal issues, kind of what I was talking about a little bit earlier with your legal question and the case analyses that you're doing. The question that we kind of need to ask ourselves is, when is it justified to deprive someone of their rights of life, liberty, or property? And then also with that, if we're going to deprive them, what processes must be followed before we can deprive them of those rights? Now, those processes, that's where due process comes in. Okay, that's what due process is. The due process has its basis in social contract theory, and this was espoused by quite a few different writers back to ancient philosophers such as Plato, and you can see the others there on the screen. That the tenets of social contract theory are present in both the First and 14th Amendment definitions, and that social contract theory basically says that by nature, you as an individual, that we as individuals, we've got basic rights of life, liberty, and property. That even beyond, if there were no laws, that we do have a right to live, that we do have a right to express ourselves and to live freely, and that we've got an innate right to own things that we've earned. Okay? That even if there was no law, that social contract theory says that we have those basic rights. That in nature, even when we're ungoverned, that the individual has natural freedom, but there are some things that limit that freedom. That there is the law of the jungle, or might makes right. That law of the jungle, that if you are the fittest, that you get to make the rules, okay? And that, but contract theory basically says we've got those rights, but even if you've got those rights, there are things that happen just in nature that could limit those rights. And so it also says, and this goes back to our question from the beginning, that food for thought question. When an individual submits to being governed, notice I said submit, because you are consciously putting yourself under a set of laws, a set of structure, a set of parameters, that you are willingly giving up some of your natural freedom. Okay? So the answer to that question that I asked at the beginning of the evening, which most of you got to in your responses, was that we are giving up some of those rights because there is a structure here. And so that you are then making a social contract with the government, supposing that the government can protect your rights, protect our rights better than we can alone. Okay, and I think Joseph, I think maybe said something that was basically very close to that. That the contract includes an understanding that the government will not limit our rights arbitrarily, capriciously, or unreasonably. So that's where this idea of due process came from. That it is social contract theory that has been around for literally thousands of years, that there has to be some type of due process if we're going to limit these innate rights that these philosophers and scholars believe that every person has, whether there's really rules, laws, or not. Okay? So this kind of supersedes the idea of law as we know it in America. So, what is due process? Well, the definition is not real clear, honestly. But as I've put on the slide here, procedures that ensure that a citizen has been treated essentially the same as another person under the same circumstances. And so that's where capricious would come in, so that we're not treating people capriciously. We're not saying one person here is going to be treated this way, but another person who does the same thing is going to be treated differently. That remember that a part of the 14th Amendment was that we are afforded equal protection under the law. Well, that's where this idea comes in, that there is no favoritism, that we're going to be treated the same way, that if I'm going to limit the rights of this person, you're going to go through a process, a procedure, that will be the same as the process or procedure that we go to for this person, if we're going to limit those things for doing the same thing, okay? And so that due process is that procedure, that unified, defined, decided upon process, that procedure that we're going to use to give you to make sure that your rights are not infringed upon. Okay? So people in a similar situation are treated differently. There must be a sound reason for the dissimilar treatment. And so if we are going to treat somebody differently, if we're going to give one person from a school concept, if we're going to discipline one person for doing X one way, but we're going to discipline this person differently for doing the same thing, there better be a good reason why you did that, and that both individuals must have received their due process right in order to treat them differently. So there has to be a really good reason if we're going to do that. Okay? There are two types of due process. There's procedural and substantive. And just like the name suggests, procedural due process has the citizen been accorded proper procedure when questioned, apprehended, or tried. Okay? That the procedural due process says there must be some type of proper procedure. You're going to find that more court cases are overturned for a lack of procedural due process than anything else. That a lot of people, and I'm talking people who are really guilty when they go to court, that more court cases are dismissed for a procedural error than for anything else. And those procedural errors are basically usually that the person was not afforded their procedural due process. Some step was missed, some step was skipped in the apprehension process, in the questioning process, or in the trial process, which then violates that person's due process right, so that we then can't limit their right to freedom. We can't put them in jail because they have not received their due process right. Does that make sense? Okay. So that's what procedural due process is, that the person must be provided notice and must be heard before taking away rights. We can't arbitrarily and capriciously assign a person a discipline in the school arena without the student having the opportunity to state their side. Why did they do what they did? What is their side? What was their take? Even if I'm an administrator and I observe with my own eyes, I observe two people fighting, those two people are guilty of fighting. They violated the student code of conduct. In the Fayette County school system, that's 5 days out of school suspension and referral to law enforcement. Okay? So you would think, I observed it with my own two eyes, I can just send them straight home for 5 days and send them to the SRO. It's not true. Both of those students, even though I saw it myself, I have to give them procedural due process, where they have to have notice that I'm charging them with fighting, and they have to have their time to sit with me as an administrator and to state their side, why it happened, what they were fighting over, what the issue was, who hit who first, things like that. Now, I may still conclude exactly the same thing, and in Fayette County I will, because we don't deal with who started it, who didn't start it. But the student is still afforded their due process right. Okay? If you have questions as I'm going through any of this, don't hesitate to interrupt me.
If you're say the example you just tossed out, if you are the witness to it, are you allowed to also be judge in that case?
Yes. Administrators are the adjudicator in the case. So even if I witness it, the chances are I'm probably going to have other witnesses as well. So I wouldn't be the only witness. Where that might get tricky, Betsy, just thinking about it, if this was this is Fayette County Schools procedure, and I can't speak for any other school system, but if in Fayette County Schools, if this was your second fight, then you're referred to disciplinary tribunal. At disciplinary tribunal, the principal typically, and we'll talk about this a little bit later, the principal typically is the one that presents the tribunal, does the questioning. If I was the only witness and I was the one taking this kid because it was their second fight, taking him to tribunal, that might get a little tricky. What I would probably do in that case is have one of my assistant principals present the case at tribunal, and then I would be the witness in that case. But yes, I still can be the judge. The administrator still serves as hearing officer, can be the witness, but would also serve as the judge. But very rarely does something like that happen that there aren't other witnesses around. Not saying it couldn't happen, but very rarely does it. Because a lot of times kids fight. There's always a function to their behavior. A lot of times they fight because they want to be seen. And so they want other people to see them. Also, that also protects them. When kids fight, there's other people around to break them up so that they know the fight's not going to last that long, but someone will break them up. Doesn't always happen, but often it does. And substantive due process, like the term suggests, is that are the laws, regulations, and policies, the substance of the law, is it fair and reasonable? Okay? Is it fair and reasonable? Is the substance fair and reasonable? So is there a law in place that's not fair and reasonable given a circumstance? So there could be a circumstance that would justify allowing someone to break the law. Point in case. When I was a teacher 1,000 years ago, it seems like, I received a phone call at school that my mother was diagnosed with cancer. I already knew she was diagnosed with cancer. She was at Emory. I received a call at school that I needed to get to school, but I needed to get to Emory very quickly to tell my mother goodbye. And so I did not drive within the letter of the law to get to Emory. I was stopped by the cops on Georgia Highway 85, headed up to Emory. I explained what happened. The cop did give me my substantive due process right. I explained what happened, and I was escorted to Emory in that case. And so I was afforded the substantive due process. The law itself in that case may not have been fair to me because of the case. If he had just given me that ticket anyway, I could have thought it, but what I would have thought was that I would not have received my substantive due process right. In that case, the law was not necessarily fair to me, with fair and reasonable in that case. Okay. So this limits the state's power to create laws that are unreasonable too. So the state just can't arbitrarily create these laws that are unreasonable that won't apply, that a reasonable person would apply to themselves. So which of these two do you think impacts schools more? Do you think we have more procedural due process things that we deal with in schools, or more substantive due process things that we deal with in school? Anybody? You're very quiet tonight. No. Well, the answer is procedural, because we have, the schools are an organization. And so you take that word, that means we are organized. We have lots of policies, lots of procedures in place. And so we do deal with, in the educational arena, we do deal with procedural due process a lot more than we deal with substantive due process. Now, people might challenge our code of conduct as being fair and reasonable, but that doesn't happen anywhere near as often as dealing with day-to-day discipline, dealing with employment law, things like that. That's all procedural due process. Okay. As I mentioned a little bit earlier, interestingly, the Supreme Court has never unanimously agreed on a standard for due process. And so as our Supreme Court changes with different, as they're supposed to be unbiased, we all know they're not. Nobody is completely 100% unbiased. But as that fabric and that framework of Supreme Court changes, so does the idea of what should be done. And so the idea of what would be adequate due process, there's never been a standard set that would be 100% adequate. Okay. And so again, this is gray area that we talked about earlier. The Supreme Court introduces that gray area, and then they have to justify whether they think someone did receive due process or whether they didn't receive their due process. Okay, so that's kind of where that comes from, and there's just more gray area here for us to wrestle with. And so it's really a balancing act. And so I don't remember who said it earlier, said that one person's rights can't infringe on the rights of someone else. Then that is really kind of the essence of what the courts deal with in dealing with the idea of due process, that we're balancing an individual's rights on one side with the necessity to protect the larger society on the other. And so as long as we're not setting up an issue where the larger society isn't infringed upon, then an individual's rights reign supreme. But when the protection of the larger society comes into play, we may have to minimize an individual's rights in order to protect the larger society. And so the courts have to make that decision as to whether it was warranted for a person's rights to be denied or to be limited. And were they guided by administrative convenience, or was it guided by a willingness to accept a degree of non-disruptive deviance? So what that term means is that sometimes we will make decisions that are just the easiest decision to make because we want to avoid a process that might be messy. And so, however, sometimes we have to give kids in the school arena specifically, we have to give kids their opportunity to state their side, even though it would be so much easier just to go ahead and suspend them and send them home. Okay. So sometimes the courts have to balance. If you've got a riot going on in your school and you make a rash decision about how to deal with multiple kids there, you read about Goss v. Lopez, and there was that involved 75 kids were suspended on the same day. OMG. I can't imagine, as an administrator this is my 13th year as administrator, I can't imagine what that was like. I don't believe I've suspended 75 kids in a year, but to suspend 75 kids on one day, the law would say all 75 of those kids really should receive their due process right. Okay, and so that's where Goss v. Lopez, where the struggle was in Goss v. Lopez. We'll talk about it more in a few minutes. Okay, so procedural due process and educational law, as we said, it most often comes into play in schools in two areas. The first area is student discipline, as most of my examples have been having to do with student discipline, because that's the job of an administrator, and in employment disputes, and as far as tenure versus non-tenure, and the fair dismissal law as to whether we are justified in dismissing a teacher. We're going to talk a little bit more in depth about both of these areas tonight. Under student discipline, we'll talk a little bit about day-to-day discipline that goes on by administrators. Hopefully, growing your worldview a little bit about what goes on in your school. This is not me trying to turn you all into administrators, by no means. It is just a way to kind of expand that worldview so that you understand the perspective from the administrator side. Disciplinary tribunals, as a teacher, you may have no idea what happens in your school or in your school system when a student goes to disciplinary tribunals. So we'll talk a little bit about that. And we're going to talk a little bit about your rights, your property right to a job, with your tenure versus non-tenure, and then fair dismissal. So that's kind of our roadmap for what's about to happen. Okay.
I have a question.
Yes, go ahead.
Okay, so just now you mentioned about the dismissal of a teacher, and earlier in the discourse tonight, you talked about people having the right to not be fired without an explanation or something like that. So my question is somewhat twofold. My understanding is that Georgia is an at-will state in terms of employment, so that an employer does have the right to terminate your employment without an explanation, and they're well within their state legal right to do so. That's one thing. And I was wondering if you could speak to that. And the second thing is that as it relates to education and teachers, since most of us, are, I guess, hired year to year because we have to sign a contract, is it a matter of dismissal, or does a school system just simply can they choose simply not to give a teacher a contract for the following year? And if so, do they have to give that teacher an explanation or whatever the case is?
And the answer to both of your questions is it depends. Don't you love that? Sorry, Tara. But if you'll just, can I delay answering your question? They're both excellent questions, but I will talk to them if I can delay till we get there, because when we get to talking about employment law, I will explain it more in depth. Okay, because they're both excellent questions. So just hang on for about 30 minutes. We'll be there. Okay. And so for student discipline, day-to-day discipline of students, let's talk about the discipline a little bit first. You as a staff member, you do have a right to due process. And that right to due process, as I mentioned earlier, is you have the right to state your side of the dispute. And, would be student discipline, whatever happened in your classroom. You got the right to explain what happened. You usually do that via a referral, or it could be via sitting down with an administrator and explaining what's going on. So that is you getting your due process rights. Your administrator may have never coined it and told you that, but that is what's happening there. You're getting your due process right. You also have the right to know that the dispute was adjudicated and settled. Now, I did not say that you necessarily have the right to know what happened. The administrator doesn't necessarily have to tell you what happened in the consequence-wise. Now, it is standard operating procedure in a lot of schools that they do let you know that. but there's not necessarily, there's no legal statute that says that you have to know that. So you just have the right to know that it was handled by the administrator, that the student was seen by an administrator, and that the situation was settled. Okay, so that is your right to know that as a staff member. The student also has a due process right. They have a due process right to know of what they're being accused, that, you know, Miss So-and-so wrote up that this happened in class. They have a right to know that. They have a right to state their side of the dispute. That's their due process right. So sometimes when you feel like the administrator didn't support you because the administrator just didn't believe you because you're the teacher, you said it, it's the fact, it happened. The administrator has an obligation to give the student their due process right. Now that doesn't mean that the administrator, who is the adjudicator, is not going to, you know, believe the teacher, but they do have a right to, or they do have the obligation to listen to the student's side. Okay. The student also has the right to have the accusation investigated, and sometimes there is no investigation necessary. Miss So-and-so said it, this is what happened, there's no investigation necessary. A lot of times the kid will go, yeah, that's what happened. And so there's no investigation necessary. But they do have the right to have it investigated, especially if there is a dispute, if there's a disagreement or discrepancy between what the teacher said and what the student said. Okay? And so when that happens, then the administrator has to investigate. So that's not a lack of support for a teacher or a lack of support of the student. It's just the student's right, because they have the right to have the situation investigated. And then the student also has the right to have the dispute adjudicated by an impartial hearing officer. In most schools, that impartial hearing officer is the administrator. The administrator is the one that, you know, doesn't have skin in that game. They're just hearing the teacher side, they're hearing the student side, and then they make a decision about what an appropriate consequence would be. Most school systems have some type of guidance for administrators that helps them determine what that appropriate consequence would be if the student is then found guilty. But it could be that the adjudicator says that, no, I believe that it happened as the student said. And in that case, you know, an investigation would have ensued, hopefully, and that they would make a calling based on the investigation that they did or based on the information that they had. Okay, so the administrator then becomes the hearing officer, the investigator, the impartial adjudicator, and that administrator can assign up to 9 days out of school suspension without further recourse. So the administrator can assign detention, can assign in-school suspension of any length, and the administrator can assign up to 9 days out of school suspension without further recourse. Now, the 10th day of out of school suspension becomes a triggering point. And that 10th day of out of school suspension, based on Georgia code, is considered a change of placement. And so before we can change a student's placement, educational placement, guess what? He has more due process rights. So a due process hearing has to be put in place before we can suspend a student longer than 9 days. Sarah, did you have a question?
Yes. Is that 10 days for one incident or 10 days throughout the year?
Well, it depends. 10 days throughout the year for a regular ed student. 10 days total. 10 days per incident from a regular ed student. 10 days total for a special education or 504 student.
Right.
And we'll talk more about that in a few moments too. Special education students and 504 students are afforded additional due process rights that we'll talk about more in depth in a couple of weeks. But as far as this administrator goes for this example, let's assume it's a regular ed student and the administrator can assign up to 9 days without further recourse. But if they go to that 10th day, then we have to afford students a greater level of due process, which is the disciplinary tribunal. Okay, good question though. So some frequently asked questions. Do parents have to be present when a student is questioned? Well, based on your reading last week, you know that no, administrators act in loco parentis, and since administrators are acting in loco parentis, then the parents do not have to be present. and that the school can proceed questioning students, can question staff members without parents present. And you may sometimes, as an administrator, have a parent that says, I won't let you question my child. Right? You may never question my child. And I can very politely say, I'm sorry, sir, but I do have the right to question your child anytime because I'm acting as their parent here. I will call you. I will let you know what happened. But I do have the right to question your child. And I can do that in courts. The courts support me there as administrators. Can a student or his personal effects be searched in an investigation? You know the answer to that, right? And the answer is yes, as long as the administrator has reasonable suspicion to believe that the student has something on him that was used to break a rule. If he's done something that's broken a rule or something that seems to be or could be used reasonably to break a rule, then yes, the administrator has the right to search. Does the accusing staff member have a right to know the outcome of adjudication? The answer is no, only that the dispute was adjudicated and settled, that it often involves other students, and that is protected by FERPA. And so that's where some of that comes in. If kid A, who you taught kid B, who you don't teach, you really don't have any right based on FERPA to know what happened to kid B or how this was adjudicated with kid B. And so I do know some school systems, it is their standard operating procedure, however, to let teachers know that, you know, the kid received 5 days out of school suspension or received 2 days of administrative detention or whatever consequences you use, restorative justice, etc. But as far as rights go, you don't necessarily have that right. Sarah?
That's the same with parents, right? That they can't know if the other person got consequences. Is that right?
That is exactly right. FERPA does the parents, as long as the kid is 18 or under, that they are under 18, excuse me, then the parent does have the right to know what happened to their child, but they have no right to know what happened to anyone else. Parents hate that part of FERPA, but it is that is absolutely correct. They do not. Administrators can never talk about what happened to another child. Some things that come into play under FERPA, Family Educational Privacy, the Right to Privacy Act, is that, you know, you have school surveillance video in your school. Often when a kid does something that they get in trouble for, a parent will want to see the video. If their child is the only person in the video, then the parent can see the video. But if the child is doing something with another child in the video, and both children are breaking the student code of conduct, the administrator then would be violating FERPA to show the video to either parent. When we go into a disciplinary tribunal and it's a closed environment where people from the outside can't come in, sometimes videos will be shown that way in that closed environment, but it would be a violation of FERPA for me to show a parent another student violating the student code of conduct. That would be a violation of their privacy. Okay.
Would part of the due process for a staff member be that you see that the behavior write-ups have been logged into the system?
Would it be, I'm just trying to restate your question. Is it part of your due process right as a staff member to see that the write-up was logged in the system? Well, I am trying to think. I can't imagine a situation where it would not have been logged in the system unless the administrator decides nothing happened. But you would have the right to know that nothing happened.
Lead them?
Sorry.
Yeah, you know what I mean. Well, because we have a problem. We had a problem this last year at our school. The reason why our principal was, because for the last 2 years, she's not been putting behavior write-ups in the system. And so purposely leaving them out and just letting them sit to the side in stacks until such case. We had 2 cases where the students actually got so severe that they did have to go to tribunal, and then it was a rush to get them entered into the system right before the meeting. And so that's when teachers realized, because someone said or revealed that those write-ups have not been going into the system. So teachers are doing write-ups on, we have a very, very serious problem with behavior at our school. And so someone, teachers are doing write-ups and they're going nowhere. No one's addressing them. No one's doing anything with the students. No one's doing just anything with the write-ups. And so it's only because they tried to backdate and get him in the system right before the meetings that they got caught. So, now teachers are like, oh, why are we even doing write-ups?
We've had to screenshot some of ours when we send them to a specific administrator or put it in the contact log.
Well, I always photocopy mine before I ever turn them in. So,
ours all go through Infinite Campus. So, ours are all electronic.
Yeah, we're still writing them manually. So I just wondered if maybe, that would be a part of due process, to make sure that as a teacher that what you're writing up is actually being addressed and logged, so that administrators are actually looking at it, doing something about it. I mean, they can choose not to do something for the student, but that it's actually being looked at.
I would say yes, that it would be part of your due process that the student is adjudicated, the student is seen. That in the case that you're describing, I think there's bigger problems there.
Right. No, we have a new principal this year. We have a brand new principal, and that was part of the issue that's supposed to be addressed this year.
Yeah. Well, it sounds like that, from what I'm understanding, that there could be a falsification. That could be seen as a falsification of records, because we are definitely accountable for our discipline data, and if things are not entered into the system, then you are not being totally forthright with what happened in the school. Whether it makes your school look good or bad, it is what it is. It's just numbers, And so I would say there's bigger problems there than due process. The falsification of records, that's an ethics violation.
Yeah.
I think that does happen though, just because of the effects of CCRPI. You know what I mean? Like everyone's all concerned about their CCR. I'm not saying that it's right. I'm just saying I've seen that happen in more than a school,
Mm-hmm.
Oh, I believe it. I definitely believe it happens. That's why I said, when I gave you the disclaimer 5 weeks ago, the disclaimer was, I'm going to tell you what the law says, and I'm not telling you what might be going on in your school and what I've heard that stuff like that happens. It's not supposed to. There should be an accountability system there. And to answer the original question that Candy asked about, would it be your due process right to know that it was entered in the system? I would say no. I would think no, but that the student was seen, yes. But there are other problems about it not being logged into the system. And so that would be problems that a school system would definitely have to deal with in that situation. But I think you're right, Tori. I do think it all has to do with the transparency of what goes on in the building. That there's numbers that are out there, and it does come into our school climate rating score in Georgia and things like that, and and it's going to catch up with you one way or the other, so you might as well not fight it. It's kind of my opinion as a principal. If you see the issues, if there are numbers out there that don't look favorable about my school, then I need to have a school improvement plan and school improvement goals that will address those things that are not favorable about the school. That's kind of how that works. If we were perfect, if our numbers look perfect, and we all know that's not what's going on in the school, then your school's got bigger problems to deal with than those numbers that are on the CCRPI. Question 4, do parents have a right to know the names of other students or consequences in a dispute? We already talked about that. And the answer there is no, that is protected by FERPA. All right, so some representative case law, and kind of like we did last week, I want to present, we don't have anywhere near as much case law tonight to look at, but we do want to look at some case law tonight. And you've got the graphic organizer that is available in Canvas. I put it in a link to it if you want to use that. I hope that helped you when you get it all in one place when you sat down to work on your midterm exam. So you do have a graphic organizer that you can write down or record some of this case law that we're going to talk about tonight. You also have a link to some of the synopses of different cases that we're going to look at. Well, the first one is Goss v. Lopez. Okay, so somebody give me just that was one of your pre-readings for tonight, was to look through Goss v. Lopez. Somebody just give me the Reader's Digest version of what was the situation in Goss v. Lopez. I hear crickets.
The students were suspended but didn't have the due process.
Okay. Students were suspended without due process, and that was part of there was a riot, 75 students were suspended. There were multiple cases, actually, that were part of Goss v. Lopez, where we talked about different situations where students were suspended, sent home without any type of due process right. Principal saying, you can come back and we'll have a meeting later to talk about placement. But that did kind of result that 10-day suspensions, any suspensions longer than 10 days must be afforded a due process hearing. And so that due process hearing at a 10-day suspension is a disciplinary tribunal. So that's what came out of Goss v. Lopez. So we won't read that one again. I'm going to actually, no, I'm not. Can somebody read for us Ingraham versus Wright, 1977? Got a volunteer? There's not that much to read tonight, so I won't make everybody read. Sarah, Sarah, I saw Sarah's hand. Sarah, if you'll go ahead and read.
Okay. In the 1970 to 1971 school year, many of the 237 schools in Dade County used corporal punishment as a means of maintaining discipline pursuant to Florida legislation and a local school board regulation. The statute then in effect authorized limited corporal punishment by negative inference, prescribing punishment which was degrading or unduly severe, or which was inflicted without prior consultation with the principal or the teacher in charge of the school. The regulation, Dade County School Board policy, contained explicit directions and limitations. The authorized punishment consisted of paddling the recalcitrant student on the buttocks with a flat wooden paddle measuring less than 2 feet long, 3 to 4 inches wide, and about 1/2 inch thick. The normal punishment was limited to 1 to 5 licks or blows with the paddle and resulted in no apparent physical injury to the student. School authorities viewed corporal punishment as a less drastic means of discipline than suspension or expulsion. Contrary to the procedural requirements of the statute and regulation, teachers often paddled students on their own authority without first consulting the principal. Petitioners focused on Drew Junior High School, the school in which both Ingram and Andrews were enrolled in the fall of 1970. In an apparent reference to Drew, the district court found that the instances of punishment which could be characterized as severe, accepting the student's testimony as credible, took place in one junior high school. The evidence, consisting mainly of the testimony of 16 students, suggests that the regimen at Drew was extremely harsh. The testimony of Ingram and Andrews in support of their individual claims for damages is illustrative. Because he was slow to respond to his teacher's instructions, Ingram was subjected to more than 20 licks with a paddle while being held over a table in the principal's office. The paddling was so severe that he suffered a hematoma requiring medical attention and keeping him out of school for several days. Andrews was paddled several times for minor infractions. On 2 occasions, he was struck on his arms, once depriving him of the full use of his arm for a week.
And so I think a lot of you are jealous now and wish that you had the ability to paddle in your classroom, right? I remember it when I was in junior high school. I remember a junior high school teacher that had what he called the Board of Education, and he would put the Board of Education to the seat of the problem, and that's just how things were done there. So what came out of this case that really could be a case of cruel and unusual punishment was that corporal punishment or any accepted form of punishment short of a 10-day suspension does not require formal due process hearing. But that doesn't mean that what happened in this case was right. It's just that that anything short of a 10-day suspension does not require formal due process. Now, the students in this case should have received some type of informal due process, so they should have had the ability to state their side, but it doesn't require any type of formal due process was what kind of came out of the case in 1977. So let's look at what this formal due process is. So student disciplinary tribunals is a formalized due process hearing that is triggered by a 10-day out of school suspension that should be aligned with whatever your school's code of conduct is. That, as I mentioned before, that the 10-day suspension is seen as a change of educational placement. And we can't make a change of educational placement without there being a due process hearing afforded, okay? That this does have implications for FAPE, that students have the right to a free, appropriate public education, and that comes from IDEA, which is federal legislation, and that they have the right to education in a least restrictive environment. So if we're going to just repeatedly send kids out of school, then we are changing their educational placement. They're not going to be in an educational setting to be able to be educated. And so that's where that 10-day trigger came from, that at 10 days it was seen as a change of placement, and so that a formalized due process hearing would have to be put in place, also known as a disciplinary tribunal. So in that disciplinary tribunal, that the formal process included certain things, that there must be formal written notice to parents with discovery, and that discovery, it means that you have to let parents know, or school systems have to let parents know exactly who's going to be testifying on behalf of the school. They have to let them know what the child is being accused of and what the investigation that ensued entailed. All that has to be given to parents in writing. I can tell you in the Fayette County schools, when I send someone to disciplinary tribunal, I have to send 2 copies of the letter, one in snail mail and one in certified mail, to ensure that parent receives that formal written notice. If they don't, and they don't sign for it, or there's not an attempt to send it multiple ways, then that could be a procedural due process error. So I have to show that I sent it certified mail. Not that they necessarily signed for it to get it, but I have to show that I sent it, that I made the due process attempt to send it. In loco parentis does not apply in a due process hearing, because this is formalized notice has to go to the parent. That there has to be a statement of accusation and a violation of the code of conduct. So the student has to know exactly, or the parents have to know exactly what the student's being accused of and how it violates the student code of conduct. There has to be an impartial hearing officer. Both sides must be heard, both the student side, that could be from the parent or an attorney, and the school side can be heard. That could come from the school principal, an assistant principal, or from the school system attorney. Both sides have the right to legal representation, because it is a legal due process hearing. There must be a trained tribunal adjudication panel. In most school systems, the tribunal is 3 individuals, thus the tribunal. It's usually an administrator, a counselor, and a teacher who know nothing about the case. Now, I do know some school systems don't necessarily use the tribunal. They sometimes have hearing officers that will make the decision themselves about longer suspensions, longer than 10 days. And so that happens occasionally, and I think the law does allow that. But in most cases, the tribunal is that triumvirate of an administrator, a counselor, and a teacher. Both sides can call witnesses and present evidence. Both sides can cross-examine. It looks very much like a court system for schools. There are 2 phases. The first phase is the guilt and innocence phase, where the tribunal panel determines whether or not the student violated the student code of conduct. If the answer is no, the student didn't violate the student code of conduct, then the tribunal's over. The student goes back to the school as a student in good standing, and it's done. If they say yes, the student did violate the student code of conduct, it goes into second phase, which is the punishment or consequence phase, and the school and the parent present information that they want the tribunal panel to consider, and the tribunal panel then decides what a logical or appropriate consequence would be. And they have the right then to assign consequences that are longer than 10 days of suspension. And so they could actually expel a student. It could be anything as light as the student returns to the school after the 10-day suspension as a student in good standing. It could be all the way up to total expulsion of the student from the school system. In most cases, it's something more along the lines of the student is suspended for the remainder of the semester with the opportunity to enroll at an alternative school if your system has an alternative school. Or it could be long-term suspension for the remainder of the year with the opportunity to enroll in the alternative school, or it could be permanent expulsion from schools. In my experience, I've never seen a situation where a kid was totally expelled from schools without the ability to go to the alternative school. I'm not saying it doesn't happen. I've never seen it in my 30 years as an administrator. Question?
Yes. So you're telling me, okay, I know that we're not saying whether our schools are doing things right or wrong, but you're saying that if a kid gets 10 days of suspension, in Cobb we call it a hearing that they have to go to. Is that, am I equating a hearing to a tribunal? Okay.
Probably so, yes.
So any child that gets 10 days of suspension, regular ed child, they're supposed to go to a hearing.
If they get 10 days in one incident, yes.
In one incident, yeah.
It triggers it at 10 days.
Okay.
That's correct.
Wow.
And you're making a face like that doesn't necessarily happen.
We definitely aren't doing that. Okay. All right. Good to know.
Yeah. So the way the law is written is that the administrator has the right to suspend a child up to 9 days without further recourse. Beyond 9 days for one incident, then the student has due process rights. Now, your system may be given due process rights in another way that I'm not aware of, but I don't know that.
What if the parents aren't challenging it, though? You know, if the parents are sign something to say they're okay with the discipline, then maybe that's why there's not a tribunal or.
Yes, and that's exactly what this says, where it says can be waived in the two phases, the guilt and innocence phase and the appropriate punishment phase. Yes, it can be waived. And so when I send a student to tribunal as an administrator, when I send them that charge letter that goes home that has to be sent, that's that notice, that formal written notice. I will often then call a parent and follow up and have a conversation with the parent. The parent can decide to waive either phase or both. They could say, I'm going to waive my right to due process hearing. Yes, my child did this. Yes, my child brought drugs to school and sold drugs to another kid. You know, I tell the parent, we got it on video. It's very clear. We can see it. Yes, your child sold drugs to another kid. That parent may then say, well, there's really no need to go. It's just kind of like pleading guilty. There's no need to go to tribunal. I'm going to waive the whole thing. Okay, which means that they're going to accept whatever my recommended punishment is as principal, which in that case, the punishment would probably be long-term suspension for the remainder of this semester and all of next semester with the opportunity to enroll at our alternative school. That's usually what would happen in that example that I gave you. The parent could say, we're fine with that. Let's go ahead and get him into the alternative school. I'll waive the whole thing. So we never go to tribunal in that case. The parent could also just waive the punishment. They could just waive the first part. They could say, yes, we believe my child did it. We're going to waive the first phase, but my child's a good kid. He needs to come back to school. You know, being out of school and going to the alternative school for the rest of the school year, that's too much. I want to put, his youth minister on the stand and his different character references to say how detrimental that might be to him. And so the parent can waive the first phase. In that case, then the tribunal panel just goes to the second phase. We summarize what happened in the case, let them know that the parents aren't disputing the fact that it happened, and then it goes to the second phase and they decide the consequence. And so that may be what's happening, Sarah, that it's just that the tribunal or the disciplinary hearing is being waived. That does happen more often than not. I mean, this year, well, not a good example because my kids really behaved well this year. I didn't have
ours either.
There have been some situations where I would send maybe 10 kids to disciplinary tribunal in a year, but I would only present a tribunal 2 or 3 times. I mean, it's more often than not parents waive.
There's times at which, though, that our kids are getting 10-day suspensions. And in my position as an academic coach, I'm working closely with admin throughout the year. So they're telling me all the things that are happening with discipline and, you know, oh, I got to go to a discipline hearing coming up, da-da-da. But there are so many kids that are getting 10 days that it's just, you get 10 days, you come back after the 10 days. Like, it's, they give 10 days out like they give a day of ISS out, you know? I mean, so it's interesting to hear this.
Okay, all right. Well, this is where due process law comes in. I didn't say that it's necessarily being done right in every place, but it is where it comes in.
I was going to say, how involved are your parents in this district?
In my school district?
They're not.
No, there you
Our
go.
parents are
That's
not
why.
involved at all.
Nobody's questioning it. See, we have
Right.
multi-million-dollar kids, and then we have, like, where I teach, so their parents are super involved. Half of them are lawyers. I mean, we're going straight to the process.
Well, and it could be that, you know, I mean, there's certainly things that go on that, you know, you can get away with without being challenged, but that doesn't make it right. But so I'm not one to question what the Cobb County School District is doing. Just telling you what's out there and what the law says. The tribunal has the authority to assign consequences beyond the 10 days, as I mentioned earlier. They can give long-term suspension, expulsion, or permanent expulsion. And but the decision can be appealed to the local school board, the state school board, the Supreme Court of Georgia, and then the federal Supreme Court. And so because it is a formal legal due process hearing, people do have the right to appeal. And so you know, I do have cases that I've dealt with that have been appealed all the way to the state Supreme Court. I've not had any get to the federal Supreme Court. That's not a challenge. Doesn't mean I want to. But I have had a case that got to the state Supreme Court. Now, every time the local school board, the state school board, the state Supreme Court all upheld the decision of the tribunal panel. I, as a principal, this is just, you know, no extra charge for my opinion. But I, as a principal, I won't take a kid to tribunal unless I know I'm going to win. If the case is not strong, then I'm going to do some other type of discipline that doesn't get to the 10-day suspension. I can suspend that kid up to 9 days without taking him to tribunal. And so that doesn't mean I won't apply a consequence, but I'm not going to put the family through that unless I know that I'm going to win. I've got a strong case. There's not a lot of gray area there, that it really is true. And I've never lost a tribunal because of that. So some frequently asked question, are the procedures the same for special ed and 504 students? We've already answered that question. The answer is no. Special education and 504 students have additional restrictions for FAPE and LRE, the free and appropriate public education and least restrictive environment. And so they have additional layers of due process. I will tell you that one of the most heated and contentious nights that we talk will be about special education discipline. Because a lot of people don't agree with that part of special education discipline. And that's okay. If you're a special educator, it'll be really interesting to hear your take on how those that special due process rights are in place for special education students. But no, it is different for special ed and for 504 students. Even 504 students have the same protections that special education students have. If parents have legal representation, does the school also have legal representation? And it is, they don't necessarily have to, but the school can, which is standard operating procedure in many school systems, but there's no requirement. In Fayette County, I will let you know that if the parent does have legal representation and the attorney presents the tribunal for the parent, then the school system attorney has to also be there. They don't necessarily present the tribunal. I might still present the tribunal, but the school system attorney would be there to make sure that the parent's attorney is not running roughshod, because, you know, I'm not an expert in the law, so they would need someone there that would know more about the law than principal would. If parents have legal representation, who presents the case? That would be the attorney, and usually the principal for the school. Does the student have to accept the punishment of the tribunal? The answer is no. The parents could make the decision at that case to withdraw the parent, or to withdraw the student and to proceed with education somewhere else. Now, we do have compulsory education law, and so kids under the age of 16 have to be educated somehow. But the parents can make the decision at that point to homeschool, or they can transfer to another school system. Now, in Georgia, the disciplinary record will follow that student. And so if there is an unsettled discipline, most likely that new school, the receiving school system, is going to probably require the family, to satisfy whatever the decision of the disciplinary tribunal had been before they'll enroll the kid. But that doesn't mean they can't go to private school. They can go to private school. Private school makes their own rules, and they don't have to follow any type of disciplinary decision based on the public school. Okay, so parents don't have to necessarily take it. They can withdraw the kid and go somewhere else. All right, a little bit of representative case law about tribunals. Somebody read for us Gonzalez versus McEwen. Who will read for us? Somebody read for me.
I'll read.
Thank you.
11 high school students, by their next friends, have brought this action under the Civil Rights Act 42 U.S.C. 1983 and the Due Process Clause of the 14th Amendment to the Constitution of the United States. The case stems from the suspension and expulsion of the named plaintiffs from Oxnard Union High School following a period of student unrest on campus during October 14th through 15th, 1976. The plaintiffs were charged with having committed certain acts which, it was alleged, led to a riot at Oxnard High School on November 12, 1976. This court entered a temporary restraining order directing the superintendent and district to reinstate 9 students, the original named plaintiffs, and to permit them to make up work they had missed during their involuntary suspension, pending a hearing on their proposed expulsion before the board. Subsequently, corrected notices were sent by the district to each of the plaintiffs except Barrington and Munden, specifying the changes against each plaintiff and also setting forth the rights of the plaintiffs as required by 10608D of the California Education Code. Hearings were conducted by the Board of Trustees during the latter part of November and early December. Because the charges against some of the plaintiffs grew out of the same incidents, hearings were consolidated for some plaintiffs. Individual hearings were set for the other plaintiffs. The board sustained the charges against all the students and found that there was just cause for expulsion. The students were expelled for the remainder of the 1976-1999 school year. Plaintiffs contend that their rights to due process have been violated by the defendant's failure to attempt milder measures of correction before imposing the harsher penalty of expulsion.
Okay, so we've got a situation where it's some interesting things happened in that case. That some of them had a hearing together. I'm not sure how privacy was held in that situation, but what came out of it is that notice of the constitutional rights must be afforded to parents and students before a disciplinary tribunal is convened, that their rights were not explained and were not given to them, and so that constitutional rights must be afforded to parents and students, that they do have the right to due process, individual in this case. We could never do a due process hearing, a tribunal hearing of multiple students at the same time. That would be an administrative convenience, especially if you're dealing with lots of students that did the same thing, like one student distributing drugs to multiple students in the school. It certainly would be convenient to be able to do a disciplinary tribunal with all of them at the same time, but the law, this representative case law, will not allow that. Zamora versus Pomeroy. Zamora versus Pomeroy. I need a reader, please.
I've got it.
Thank you.
This civil action was brought by the mother of an allegedly aggrieved high school student who maintains that his civil rights were violated contrary to the 42 U.S.C. 1983 Civil Rights Act of 1871. The son is a minor, and hence the suit was brought on his behalf. The source of the claim is the conducting of a warrantless search of his school locker. That search revealed the presence of marijuana, and the alternate contentions are that it was unlawful to use sniffer dogs to discover the drug, and that after discovery of it, a warrant was essential to the opening of the locker and the removal of the marijuana. The search referred to did not originate as an investigation of the minor son of the plaintiff. It was a general investigation. The assistant district attorney of the county in question contacted Mr. Worley, then assistant principal of the Roswell High School, about conducting a search of school lockers using so-called sniffer dogs, which dogs would be available to them sometime in the future. At that time, no specific persons were suspected of possessing marijuana at Roswell High. Permission for use of the dogs at Roswell High was not granted by Mr. Worley because he had to clear it with the principal, one Elgin Mallory. Mallory could not authorize the use of the dogs and the entry by the police officers into the school until he was granted permission by the defendant Pomeroy, the Roswell Independent School District Superintendent. After clearance was obtained from all these people and permission was granted to conduct the program, the proposed search was started. In the course of searching the lockers in the Roswell High School, a so-called hit was made by one of the dogs. It was the locker of plaintiff appellant Zamora. The locker was opened, and a substance which proved to be marijuana was found therein. Besides the substance and a leather strap, nothing else was found. Neither books, clothes, nor school supplies were in the locker. The marijuana was taken from the locker and given to Worley. He tested the substance and concluded that it was marijuana. Some little time after the test, Vidal Zamora was taken from his classes and questioned about the substance that had been found in his locker. Worley accused Vidal, based upon his own investigation, of having had marijuana in his possession. Zamora denied any wrongdoing and denied that the marijuana was in his possession. He said that he was not using that locker, but was using one in what was called the Vocor building. Vidal was called out of class a second time. He contends that he was pressured by the defendant to confess that the alleged marijuana was his. On one occasion during the questioning, Vidal discovered that Worley was using an electronic recording device, although permission had not been asked to record his statement. It is also pointed out that he was not warned about self-incrimination. The relevance of this failure is questionable because this procedure is not criminal in nature. During the time Vidal was being questioned by Worley, he was given the impression, so it is maintained by counsel for Zamora, that it was his obligation to prove his innocence, and he was not told that he could confer with counsel. Soon after these happenings, the appellant, Vidal, was transferred from Roswell High School to the district's Educational Services Center, another high school within the city which did not have the academic standing of Roswell High. An objection is made to the fact that Mrs. Zamora, the mother of the boy in question, did not receive notice through the mails as to what was happening. She did not, for example, receive notice, for whatever value it may have here, that charges were filed against the boy in school. Worley said that he could not get hold of her on the telephone because she did not have a telephone, and he did not mail a notice to her because he did not have an address for her.
All right. So remember, this is 1981. This is a while ago, but 1981. So there's lots of things that happened in this case. Things that related back to your last week's reading with the use of a drug dog and things like that. And incidentally, most school systems do allow drug dogs to come into their school system, and they can if they make a hit on the locker, the drug dog, the courts have upheld that the drug dog hit does give reasonable suspicion, and so that can be, you can then search lockers. That also, drug dog hit is probable cause, and so in that case, an SRO could even search a locker in that case. But from what the relevance to our discussion tonight is that the decision was made to send the student to another, an alternative setting without notice being made to the parent. So you were going to send your child to an alternative setting that doesn't have the same academic standard as the school that you're in, and we're not going to tell you about it. And so the parent, you would think, common sense would tell you that the parent has a right to know. Okay, and so due process was not followed in this case because the administrator made an attempt to call, but the parent doesn't have a phone. And so that's why there now has to be formal written notice in a case of transferring a student. So that written notice must be provided to the parent and student. A meeting must be held to discuss the situation, and the meeting must allow for witnesses to be presented and examined. So that's what came out of it. Some of those procedures, some of those processes, if you will, were solidified and ratified because of Zamora versus Pomeroy. All right, let's talk a little bit about, let's transition a little bit to talking about your employment rights. We said the other area where we use due process in school is the idea of teacher employment and fair dismissal. Now, in Georgia, we are a right to work state, and so we don't have any type of teacher unions here. The question was asked about an at-will state. Teachers are afforded tenure in Georgia unless your school system has waived tenure. That's a whole nother discussion. I'll get there in a minute, so hold on. But we do have tenure in most cases in Georgia that if you have tenure in Georgia, what that means is that for you to be dismissed from an educational institution because you're a contracted employee, that you, once you have tenure, you are afforded formal due process rights before dismissal, that you have earned a property right and you have earned the right to expect another contract once you have received tenure. Now, tenure in Georgia happens when you receive your fourth contract. So first year you get a contract, second year you get a contract. During your third year, in most school systems, it happens in around March the 1st, March the 15th, something like that. When the school system offers you your fourth contract, you are then tenured in Georgia. And so what that means is you now have the right to formal due process before you are fired. Now, I did not say that you couldn't be terminated. You can be terminated even if you are tenured, but you have the right to a formalized due process hearing. That due process hearing in Georgia happens before the Board of Education, and then the Board of Education decides whether or not they will uphold your termination based on the evidence that's presented before you. Someone asked the question earlier about, can they just decide not to renew your contract? The answer to that question is no. The answer to that question is no if you're tenured. If you are tenured, you have a property right. You have earned the right to expect prolonged employment. So if I've worked in a school system for 5 years and I have tenure then, because I've worked in that school, that one system for 5 years, then I have a property right to expect continued employment. I have a property right to expect that they're going to give me a new contract. And so if they are going to non-renew you after you have tenure, then they have to provide notice. They have to provide notice by May 15th in Georgia. They have to provide notice they have to give you notice of non-renewal, and that notice has to say that you have due process rights, the right to a due process hearing. And so you then could take the school to, or you could then have an attorney that could go and present a due process hearing before the school board, and the school board will decide whether to uphold or the non-renewal or whether to reinstate you as a teacher. If you are non-tenured, you've not gotten your fourth contract in a system, then you don't have due process right. You don't have any right, you don't have that property right to expect further employment. And so the school does not have to say anything to you. They have to tell you you're being non-renewed, but that's it. They have to give you notice of non-renewal, but they don't have to do anything else. And so that's because you don't have a property right, so they're not limiting any of your rights to property, life, life, liberty, or property there in that case. You still have your 5th and 14th Amendment protections of due process, but you don't have that property right for formalized due process, okay? If you move to another school system, just so you know, and you've had you've had tenure in one school system, you don't have tenure in the new school system, however, until you're offered your second contract. okay? So let's say I work in Fayette County Schools and next door is Coweta County Schools, and I decide that, you know, I've taught in Fayette County Schools for 5 years. I have formalized due process. I have tenure, but I leave Starrs Mill High School and I go to East Coweta High School to teach. I lose my tenure when I go to East Coweta until they offer me my second contract. When they offer me my second contract in Coweta, because I was tenured in Fayette County, then I am then also tenured in Coweta County, okay? If you never receive formalized tenure, however, you start over in the new system. So if it was my second year in Fayette County and I had not received my fourth contract and I decided to leave Fayette County and go to Coweta County, I then start that 4-year cycle, the 3-year cycle, fourth contract cycle over again to receive formalized due process rights, okay? Now, that being said, in Georgia, all school systems last year or year before, don't quote me on that, had to all declare whether they were a charter school system, a strategic waiver school system, or a status quo school system. There are only, out of 170 something school systems in Georgia, only 2 school systems remain status quo. Okay, so that means most school systems in Georgia are either charter school systems or strategic waiver school systems. And what that means is charter school systems can waive certain rights or certain regulations as long as they have accountability for waiving those regulations. One of the things that are commonly waived in school systems in Georgia are tenure. And so even though you may have worked in a school system for 5, 7, 10 years, your school system, if they're charter or strategic waiver, they may have waived the tenure requirements, okay? So you may not have the protections that you think you have. Administrators, by the way, never have tenure. There's no such thing as administrative tenure. Tenure only applies to teachers. And so administrators can be dismissed. So that's why when administrators don't produce, and that's why especially systems that struggle, you very often will see heavy administrator turnover. That's because there's no tenure. You don't have property rights as an administrator, and there is no tenure, so you can be dismissed for any reason. So that is, our jobs are much more unstable than teachers' jobs are in Georgia. Okay, so even though I told you about tenure, you may or may not have it, just depending on what your school system, whether they decided to waive that regulation. Okay, if you're in a status quo school district, however, you do have tenure, and tenure is afforded that way. Okay, so we can deny someone their property right. If you're tenured, you can deny their property right as long as you give them due process of the law. Okay, so due process. Tenured teachers, school system must show cause of why they would want to not renew your contract. Things that are permissible for them not to renew your contract: immoral conduct. You have a relationship with a 15-year-old, 12-year-old. That would be grounds for dismissal. Now, you still would have your right to have a due process hearing, but that would be grounds for dismissal. Incompetence, that you can't do your job. Neglect of duty, substantial noncompliance with school laws, conviction of a crime, especially if it's a crime of moral turpitude. Insubordination, if a administrator gives you a directive to do something and you say, and it's a reasonable directive, and you say, I'm not going to do it, that could be grounds for dismissal. Fraud or misrepresentation. So when we were talking earlier about the stuff that was happening in the northwest corner of the Metro Atlanta area about not putting discipline records in, that could be thought of as misrepresentation. And so that's where I was kind of going with that when we were talking about that situation. So the idea of a PDP, that question usually comes up in this discussion. That usually someone will ask, if my I did TEKS and I received a 2 on my TEKS in an area, and my administrator put me on a PDP, and that PDP makes me do XYZ professional learning, and I have to keep all of these logs and I have to do all this. Do I have to do it? The answer is yes, you do. Because if you don't, then it's insubordination. Okay, and so TEKS does allow an administrator to put reasonable. That term is, can be left up to interpretation, but the administrator can put reasonable remediation plan in place. And if you refuse to do that remediation plan, then that could be insubordination, which would be grounds for dismissal if you have tenure. Okay, if you don't have tenure, they can dismiss you without even telling you why, because you don't have a due process. You don't have due process rights. Okay, you don't have to clear your throat. Just say Dr. Lane. It's fine.
I have a question.
Go ahead.
In reference to, you said the PDP and being insubordination, is it possible, do they have to give you reason for putting you on a PDP, or can they just put you on one? Or does it have, can you, if you're insubordination due to the fact that you feel like you didn't get, your due process and showing why you're on the PDP?
No. An administrator can put you on a professional development plan for any reason, at any time. In some schools, every teacher is on a professional development plan. And so that the administrator, the law does not limit how an administrator puts a teacher on a PDP. Now, best practices would be that there would be a reason. I don't put a teacher on a PDP unless I've given them a 2 in some area on TEKS. But no, there's no limit to that as far as the rules of the teacher keys goes. Okay. Any other questions while we're at a brief break? All right, so if you've got a tenured teacher and the decision is made to non-renew a tenured teacher, then there must be proper notice, and in Georgia that proper notice must happen by May 15th. They must know what witnesses are going to be presented, and there could be subpoena of records. There could be subpoena of people to come and present at the hearing. The time and place of the hearing must be afforded to the teacher. There must be discovery and what evidence is going to be used. There must be a fair hearing and the opportunity for appeal. In this case, usually the due process hearing happens before the school board. And if the teacher decides to appeal, the school board decides to uphold the termination of the teacher, then the appeal would go to the state school board. Okay, so those hearings are usually recorded, and they're usually recorded so that then the state school board can listen to the recording of the hearing and decide whether they're going to uphold what the lower school board decided. Okay, right. A little bit of case law here too. Somebody read for us Board of Regents versus State College versus the Board of Regents of State Colleges, versus Roth, 1972. Who will read for us? Joseph, if you don't mind, go ahead. Thanks.
Respondent hired for a fixed term of 1 academic year to teach at a state university was informed without explanation that he would not be rehired for the ensuing year. The statute provided that all state university teachers would be employed initially on probation, and that only after 4 years of continuous service would teachers achieve permanent employment during efficiency and good behavior with procedural protection against separation. University rules gave a non-tenured teacher dismissed before the end of the year some opportunity for review of the dismissal, but provided no reason need be given for non-retention of a non-tenured teacher, and no standards were specified for reemployment. Respondent brought this action claiming deprivation of his 14th Amendment rights, alleging infringement of his free speech right because the true reason for his non-retention was his criticism of the university administration, and his procedural due process right because of the university's failure to advise him of the reason for its decision. The district court granted summary judgment for the respondent on the procedural issue. The Court of Appeals affirmed. The 14th Amendment does not require opportunity for a hearing prior to the non-renewal of a non-tenured state teacher's contract unless he can show that the non-renewal deprived him of an interest in liberty, or that had a property interest in continued employment despite the lack of tenure or a formal contract. Here, the non-retention of respondent, absent any charges against him or stigma or disability foreclosing other employment, is not tantamount to a deprivation of liberty, and the terms of respondent's employment accorded him no property interest protected by a procedural due process. The courts below therefore erred in granting summary judgment for the respondent on the procedural due process issue.
All right. So tenure is a property right earned by process. Therefore, non-retenure teachers are not afforded due process because they do not have a property right in their job, which is basically what I described. Even though this was a university setting, it sounded very similar to how due process is afforded. Due process right is afforded in Georgia. That thought of continued employment is a property right. Remember when we talked about property rights, we said that property rights are, I worked for it, I earned it, it's mine. That's kind of what, once you get to that fourth contract, you've worked for it, you've earned it, you have the expectation of continued employment. That's what tenure is your expectation, okay? One more, Perry versus Sinderman, 1972. Will someone read that one for us? It's our last one tonight. Who will read for us?
I'll read it.
Thank you, sir.
The respondent was employed in the state college system for 10 years, the last 4 as a junior college professor under the series of one-year written contracts. The Regents declined to renew his employment for the next year without giving him an explanation or prior hearing. Respondent then brought this action in the district court, alleging that the decision not to rehire him was based on respondent's public criticism of college administration, and thus infringed his free speech right, and that the Regents' failure to afford him a hearing violated his procedural due process right. The district court granted summary judgment for petitioners, concluding the respondent's contract had terminated and the junior college had not adopted the tenure system. The Court of Appeals reversed on the grounds that despite lack of tenure, non-renewal of respondent's contract would violate the 14th Amendment if it was in fact based on his protected free speech, and that if respondent could show that he had expectancy of reemployment, the failure to allow him an opportunity for a hearing would violate the procedural due process guarantee. Held, number 1, lack of contractual tenure, right to reemployment taken alone did not defeat respondent's claim that the non-renewal of his contract violated his free speech right under the First and 14th Amendment. The district court therefore erred in foreclosing determination of the contested issue, whether decision not to renew was based on respondent's exercise of his right of free speech. 2, though the subjective expectancy of tenure is not protected by procedural due process, respondents' allegations that the college had a de facto tenure policy arising from rules and understanding officially promulgated and fostered entitled him to an opportunity of proving the legitimacy of his claim to job tenure. Such proof would obligate the college to afford him a requested hearing where he could be informed of the grounds for his non-retention and challenge their sufficiency.
Thank you. So tenure applies to teachers who've been consistently employed even if no formal tenure process is in place. Okay, so he's talking about the expectancy, or Steve, you read about the expectancy of continued employment. And so in this case, there was no formalized tenure, but the courts upheld that the respondent here did have the expectancy of continued employment, because so in that case he had de facto tenure. So this would be very interesting in thinking back to what I talked about with being a strategic waiver or charter school district. If they have waived that regulation of rights, if you were terminated and because they said that you were, excuse me, you were terminated after you'd been there for 10 years, and you were not afforded a due process hearing. If you challenged it, even though they say, I think the school system would say, well, we waived that regulation, I have a feeling you would have that a lawyer would take your case, because you would have the right to expect continued employment if you had been there for a while, even though the school system waived that regulation. Was there a question? No? All right. So next week, you're going to be dealing on your own with when you consider employment law. So there's going to be more about this that we'll talk about 14th Amendment and 5th Amendment and due process as you consider how employment law impacts us as educators. So there will be more to come, and you'll be just as excited as that young lady in the picture on the slide, I'm sure. That was a joke. They don't get any better, so you might as well go ahead and laugh. All right, so we're going to wrap up here tonight. I know you're disappointed about that, but you do have both follow-up from tonight's session and then work for next week. So follow-up from tonight's section, you do have a interesting discussion post that some of you have already looked at and started on, I can see, about due process for a felon, about should a felon have due process rights. And you have a case analysis, Todd versus Rush C. Schools, 1997, and that is a case about due process. Okay, go do a case analysis there. And then next week's assignments, you do have a reading quiz. And whatever the issue is, the reading quizzes, you figured it out, because the reading quiz grades are fine for number 2. You do have a discussion and then case analysis and some ethics readings to do for next week. Okay, it's hard to believe that we're already in week 5. We're in the home stretch now. You're hanging in there. Next week, I will be on vacation. Mickey is calling and I must go. So if you text me or email me and I don't respond immediately, it's because I'm on vacation and riding roller coasters. I will check my email periodically, etc. I mean, I won't totally abandon you, but I am leaving Friday and won't be back to the Sunday a week later. So the 20th, or leaving this Friday and we'll be back to 23rd or whatever that Sunday is. Okay. Any questions, comments? All right. Well, I hope you have a wonderful week ahead. And if you need me, you know how to find me. Ciao, everybody.
Good evening.